question of balancing the right of one citizen to free speech against the right of another citizen to privacy, that is, I would suggest, one aspect of the problem of equality.
Very interesting, and if I may say so, a mildly provocative presentation, which every presentation on privacy is bound to be. The matter is thrown open to the House for interactive comments and questions.
Could I just add a footnote to Robert Walker's account? First of all, I think that judges here will be interested to know that the British Parliament has recently abolished criminal libel, seditious libel, obscene libel, and blasphemous libel, all of which are, of course, in your penal code. But we abolished them by statute, I'm happy to say. Blasphemous libel only surviving at the moment in Northern Ireland. Second point is that in the Naomi Campbell case that Lord Walker mentioned, and will in some ways create some principles which will deal with some of the grossest anomalies of libel law. It won't deal with privacy, which of course is another matter, as Lord Walker said. So Lord Walker's talk is engaging a lot of very topical matters for us, and I think that some of them have implications elsewhere. And the final thing I'd say is on New York Times and Sullivan, our courts have not done what the Supreme Court of the United States did and adopted the public figure test, which is not a rational test, since it includes baseball coaches as though they were politicians or ministers. Instead, our House of Lords, in a case called Derbyshire, held that a government body cannot use libel law, but must use malicious falsehood, the same really as the Sullivan rule. And our law lords looked at the South African case, Ishbourbon, in 1940, where that court, without any Bill of Rights, decided that a railway company shouldn't use libel law. But what we have not done is to say that the Sullivan rule applies beyond government bodies. However, unlike the United States, our courts have very sensibly capped libel damages, insisting in Elton John's case and Esther Ranson's case that damages for libel must be proportionate, and if you have a jury, the jury has got to be very carefully instructed to avoid massive damages, whereas, as you probably know, in the United States, and despite the First Amendment, there are no cases holding that excessive damages violate the First Amendment. So there are these interesting contrasts, and the fact that the Strasbourg Court has now said that excessive costs imposed on publishers of information are themselves a violation of free speech is quite significant and will stimulate the British government and Parliament to do something about the everything else in what I just said. It's quite useful to have somebody talking about the legislative side as well as the adjudicative side. Thank you very much.
Thank you very much. In our country, I just speak to you for 2 minutes. In our country, the right to privacy has now come under severe attack. It's all the result of a follow-up of the opinion of Justice Bhagavati, when his lordship in the judge's transfer case opined that the right to speak includes the right to know. Unless you know, your speech is bound to be gagged, your speech is bound to be incomplete, inadequate. By following the US Supreme Court principles of emanation, he read into Article 19(1)A, a right to know. As a result of which we have got, after 1 or 2 decades, a right to Information Act. I can inform you the Right to Information Act, the Information Commissioner is even issuing notices on the Chief Justice of India, asking him to disclose the inner working of the Supreme Court Collegium about appointment and selection of judges. You see, as a result of which some proceedings were initiated in Delhi High Court, and Delhi High Court upheld the order of the Commissioner, and Supreme Court of India for the first time in its history has to file an appeal as a litigant. The matter is pending, I can't discuss on it. But the question is this, that the right to know is now become a very important segment, eroding your right to privacy. And in the name of transparency, accountability, these are the new facets which are read into your freedom of speech. Therefore, in our country, this is a very, very challenging situation. It's a very difficult task for the judges to balance. Because I tell you, as a result of this, we have on our own, the judges of the Supreme Court on our own have declared their assets and put it on the website. And the judges have done it. So we are more and more becoming, because judges are not in that sense, a supermodel or anything of the sort. They are certainly public figures. Anyway, but this is coming up. The MPs and the ministers have to declare, the judges have to declare, the area of privacy is becoming minimized. Request others to participate and give their views. Yes.
Another important and interesting question has come up, although the case is pending in Supreme Court. How far the legitimate information collected from the legitimate exercise of taping and tapping the telephone and conversations can be put to the public.
You're talking about radio tapes.
We have a law in our country that for legitimate means we can tap the telephones for public security reasons, for tax.
It's an invasion of privacy.
Invasion of privacy, exactly. The tax evasion or friendly relation, security reasons. But when the agency is going for tapping the conversations, they come into possession a lot of other information also, which may affect others. We have a case, a very interesting question pending in the Supreme Court, that whether that part of the information which does not relate to the tax evasion, the legitimate purpose for which the phone was tapped, can be used. Incidentally, one of the persons who was conversing is a leading industrialist. He may not have nothing much to hide, but even his personal preferences, his places where he visits, what does he do, is his personal domain. It's the right of privacy. As Lord Walker said, right of privacy, there's a lot of tension and that must be protected. We remember a few years ago in UP, state of UP, tapes of one important politician, Mr. Amar Singh, were leaked out. And the tapping was also illegal. But another thing which we have to see is whether the information collected, if it is damaging to public interest, all right. But sometimes the information which comes out also shows how the government functions. In that particular tapes, we found that one of the most controversial job of the government to fix the sugarcane price for sugar industry, which used to have a lot of litigation and a lot of guidelines, were fixed by a very interesting conversation where the Chief Minister could not even hear what the other side was saying. And said, do you think that a price of that much will be sufficient? Chief Minister said, I don't know, I can't hear you properly. But then whatever you're saying is right. We have a lot of interesting issues also coming up. But this is certainly an issue which has to be addressed to, as to how much part of the conversation, part of the conversation which is legitimately correct can be put to use or can be leaked out. The another area is that WikiLeaks, which is now engaging the attention of the entire world, where certain emails sent by the high commissions and consulates were intercepted are being made public. Thank you.
Or is it something the judges will have to develop in their lawmaking function?
I can try to answer this. This telephone tapping in India is regulated. Well, old Act, Section 3 of the Telegraph Act, and presently there's a lots of, I'm on the bench. Rather, my freedom of speech is a little constrained on this subject. And others can speak on this, but as far as I am concerned, it's very difficult for me to speak on this.
In such cases, I think the right of privacy does not appear to be a new invention of a principle. This principle is inherent in the law of defamation, in the law of torts. We have already this principle. See, even in the case where you make some libel or a slander, you become liable if it is not in a public interest. The same principle applies even in the case of a tort. You give out an information of a private life of a person which is not of a public importance or public interest, then the person who violates the privacy becomes liable under the law of tort in the Indian context. And I think in this situation, and I want to know, it's very interesting that
how to balance between 14 and 32. And there is a limitation clause also. That is 36. Limitation of rights, section 36. The rights in this Bill of Rights will be limited only in terms of the general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality and freedom, taking into account all relevant factors including A, the nature of the right, B, the importance of the purpose of the limitation, C, the nature and extent of the limitation, D, the relation between the limitation and its purpose, and E, less restrictive means to achieve the purpose. Very interesting situation. I think it's very challenging. I think no other constituent subject to my limited knowledge throws this right to privacy, right of action, access, and the limitation on these rights in such clear and tangible terms. I request the learned judge to speak on this.
Well, put very briefly, I think the formulation of Article 13 or Section 13 is drawn very closely from the ICCPR, so they're quite widely recognized provisions for giving some sort of context to privacy. And in our jurisprudence, we've also, really responding to what Lord Walker said about what is the content of privacy, we've established a core and penumbra notion that the closer you come to the intimate life of people, so sexual contact, home life, the more intense your privacy interests are. The more you move out into the public sphere, the more tenuous your privacy interests are. So, for example, your privacy in your workplace is less acute than your privacy in your bedroom. And when it's then weighing the justification analysis against the privacy concerns, the importance of the purpose of the limitation of privacy will be much more easier to sustain the closer you are to the penumbra of privacy. That's a model somewhat similar to the approach in Germany, I think. In relation to freedom of information, it is unusual to find it in the Bill of Rights, but again I remind you that our Bill of Rights is a 1996 Bill of Rights, and we've been able to draw on experience in many jurisdictions and many international conventions. But as there often is, there's a little footnote to that. And the footnote is that the schedule to the Constitution requires there to be legislation enacted to give effect to the access to information right. And in fact, Parliament was put on terms to enact legislation within a 5-year period very similarly to the equality legislation which I discussed yesterday. And we call it PIRE, the promotion came into force in the year 2000, and it has a very careful and thorough dealing with what sorts of information you're entitled to, the processes for getting the information, and that information is then disclosed. I have to say that, like I think governments everywhere, that there hasn't been the most wholehearted embracing of the principles of access to information. So we are seeing quite a bit of litigation around it. But by and large, most of the information runs to talk from the state, and one individual could not seek private information held about another individual unless they could show it's directly relevant to their rights. So the potential for breach of privacy is less. What is interesting though is it does also apply, as much as the South African Bill of Rights does, in horizontally. So corporations in particular are also under obligation to disclose information, but we similarly have the data protection requirements as well. So it's always a balancing between ensuring that you balance privacy on the one hand and with entitlement to privacy on the other, on that hand with an entitlement to information. And it's very context-driven, very much like the privacy litigation that we've also discussed.
Well, what happens to paternity cases? I'm sure there are similar cases come in South Africa.
Well, paternity cases, they occur all the time, and where there are disputes of paternity, generally there will be genetic testing to determine paternity. And there are sometimes disputes about whether those tests are accurate or not.
But any paternity test has to be carried out infringing, basically. Your person has to be scratched. In that sense, you're saying nobody can touch your person, and that has to be done.
Yeah. But
because the balance has to be struck, you're right.
A balance has to be struck, and generally we have very strong rights at the trial, and where a mother can establish some reasonable connection or likelihood that the man is the father.
Nexus has to be.
Yes, she has to establish that they've had a relationship, and she has to assert all of that. Once she's done that, if he denies it, she would be entitled to insist on a paternity test. But you can't do that without some, basically, the establishment that has been made.
Can I ask a question? May I ask a question?
You immediately.
No.
Any paternity test?
No, that's beyond my I wonder whether
Justice O'Regan was explaining some of the situations in South Africa where suppose a legislation is brought about and that legislation is challenged by somebody saying that it doesn't include my interest or excludes my interest. Now, the African Constitution Court, sir, they have a right to give a direction to the legislatures to amend the law or to change the law for that inclusiveness. Now, in India, we don't. In India, we have the powers of striking down a legislation to the extent it has been enacted. The maximum we can do at times is we can make suggestions that you can do next time you do this exercise. Take care of this aspect of the matter. But we cannot refer a bill back or we cannot refer a statute back to the parliament or the legislature by saying first you do this and then we come back. So that power we have not exercised till date, we don't know in future.
But I don't understand why not, because you have an inherent discretion before granting a remedy. And I don't understand why you can't do what an English court could do, or what a South African, we don't have a written contract. But why can't you, when there's a particular problem, before giving a remedy, say that you will adjourn the proceedings for a short time,
Because
3 months, to give the state the opportunity of coming forward with a solution, rather than having it effectively to otherwise in effect weakening the parliament.
No, I can inform the House that we have done this recently in the sense of this constitution of the Green Tribunal, when it was virtually not becoming functional as the Speaker has suggested that we have heard that this has been done by the Supreme Court, that we have heard the counsel, the attorney, and the private party on the gender proceedings, suggesting them to make certain amendments. After the amendments were made, we have allowed the tribunal to function. We have done it, but not very largely, but in some extent we have done it. As has been said, that we have, it has not been, I think, it is not the major jurisprudential trend, but we have started doing it. In a sense, in a recent case relating to the constitution of the Green Tribunal, what has happened is that as soon as the Green Tribunal is constituted, all the jurisdiction is taken away. But the tribunal is not properly constituted. Then the matter came before us. So we suspended the whole thing. We requested the attorney to make an amendment, to immediately make an appointment. Until that, and they said, how do you go about our limitation or appeal procedure? We said we adopt the procedure which was there in the previous tribunal. And they have made it, they have made the notification. There was this kind of adjustment for ends of public interest, ends of justice. Please come here.
You want me there?
Oh yes, you must be the center.
Sorry. You can sit there, sir. Quite okay, sir.
There was no need.
You can come here. You can
1,000. And my judges disposed of, on an average, 2,95,000 backs. I do not think that anywhere else in the world such figures are. Yes, perhaps we have not passed many detailed judgments, but I will, while speaking, I will try to reflect as to why this is not happening. When you speak about a high court, you only don't speak about the post-constitutional laws of equality. I would also like you to take my high court back before the constitution. Now we have a large number of women judges and lawyers sitting over here. Now, up to 1919, no woman could practice in this country. 2 high courts, Justice Ganguly's parent high court, Calcutta, and the Patna High Court, Justice Katria, who is not over here now, declined to allow ladies to practice. But my high court, not on the judicial side, but on its administrative side, presided over by Chief Justice Sir Grimwood Mears, permitted the first woman vakil, as we call them, lawyer, to be enrolled as far back as 1919. And with Roshan Dalvi, my colleague from Bombay, would like to know, it was the Parsi lady, Miss Cornelia, to direct the government to issue the notification. That is the position. But post Unikrishnan, we have developed both under Article 142 and perhaps direction of 226. Now again, Article 140 is the power of the Supreme Court to do complete justice. That also is the subject matter of a debate in the courts. Earlier it was whether it was within the realm of that particular judgment. The subsequent judgments have taken the view that, well, it's not only in that judgment, it's a broader concept, broader view, we can issue directions. Now, Unikrishnan has been dissented from on most of his aspects, except on one aspect, the right of a child to education. And why am I referring to it? Because the basis for our judgment perhaps can be located in the view taken in Unikrishnan. Now, India is a party to a large number of international treaties. We have a chapter in the Constitution called the Direct Principle of State Policy. Then there is a chapter called Fundamental Duties. Now, the earlier approach to the Constitution was that directive principle is not enforceable. They are the non-enforceable part of the Constitution. Fundamental duties are non-enforceable. But starting with Jolly John Varghese and other judgments, the law said such a person should be sent to jail because he has no means to pay, then execute the decree. And one of the modes of execution was of sending him to jail. But Justice Krishna developed an very interesting thought, relying upon the United Nations Declaration of Human Rights. He said no person could be detained or sent to prison if he had no means to pay. He said India is a party to this international convention, and this forms, and if a man cannot pay, you can't deprive him of his liberty. And therefore in that case, he held you can't send a man to jail irrespective of the law that was in the country. For the first time, the Supreme Court said, if pursuant to the international conventions, directive principle of fundamental duties, if you can read them into Article 21, the part of your right to life, then there is no need for a state positive law. There is no need for an enactment to be there. It is open to the Supreme Court under Article 142 to issue directions to compel the government to enforce those conventional rights. And the High Courts, of course, followed suit under Article 226 by issuing directions. So today, in those areas where fundamental rights are involved, and if they can be located into Article 21, it is possible for this, and the Supreme Court has been doing it, Vishak and all the other judgments, of laying down directions which is not statutory law, but at the same time enforceable direction which can be enforced by a citizen by filing a petition or taking a recourse to other remedies. So therefore when I came to the Allahabad High Court in the month of June 2011, the first thing that I found was a large number of citizens coming forward, farmers and artisans, who had been unable to pay their bank loans because of a drought in the...
Thank you, but I would kindly request this august body to excuse me for my absence. Because tomorrow, I'm very heavy. And here, unfortunately, in India, the judges have more brief to read than the lawyers. Therefore, I will be excused. Thank you very much.
Yeah, thank you, Justice Ganguly, for coming. Tomorrow you have 70 matters on your board. Thank you very much, sir. And we request Justice Sunil Andwani to chair the session. We are running about 1 hour late, half an hour late. So, sir, we'll go till 12:45 for Richard Permer and Sapna Malik, and from 1:15 to 1:30, sir. Then lunch will be half an hour late. Thank you, Justice Andwani.
May I request Mr. Richard to give his presentation along with Sapna.
So, it's a great privilege to be here today to address you. It's also, if I may say, a particular pleasure to be here at the invitation of the HRLN, which is not only a well-known, extremely respected body in this country, but internationally is the subject of admiration. And if I could just say, as someone who, in my most pretentious moments, fashions myself as a human rights lawyer, spend time with Colin at his office, listening to the work that he does, is a thoroughly humbling experience. What Sapna and I are going to talk about are types of claims that have been running in the English courts over the past decade or so, in which claims have been brought by some of the most disempowered people on the face of the earth against some of the most powerful people on the face of the earth. And that was a subject that Colin asked us to talk about, not only because it has an intrinsic interest in itself, but that Colin thought it has relevance in an Indian context. Although getting that into the subject matter of equality and non-discrimination law is a little difficult. But it's about, at its heart, I think, giving equality of access to justice. And that's at the heart what these cases are about. So over the course, I think really of the last 15 years, the English courts have seen the emergence of claims in which large groups of citizens of foreign countries have brought tort claims against UK-based multinational corporations for damages that they sustained in their home state. For example, last year, on the eve of trial, a settlement was reached in a case brought by 30,000 citizens of the Ivory Coast against a commodity broker, British-based commodity broker, who were alleged to have been responsible for dumping toxic waste in the commercial capital of the Ivory Coast, causing damage to 100,000 people who required medical treatment. A year before that, there was an out-of-court settlement in a case brought against BP by Colombian farmers living in a very remote part of Colombia who claimed damages for damage to their land arising out of the construction of a pipeline. And in October of this year, the Queen's Bench Division in London is going to hear a trial brought by 33 Peruvian nationals, again living in a very remote part, very poor part of Peru, against a British multinational mining company who, it is said, were complicit in their torture and mistreatment when they were protesting about the development of the mine. We thought, Sapra and I, that perhaps an interesting way in is that Sapna will talk about some of the cases and the development of the cases over the past 15 years, and then I'll just try and tie in at the end two things. One, try and put it in its kind of theoretical context, why we've been doing these cases from a human rights lawyer's perspective. And secondly, some of the practical problems that the courts in London have had to grapple with.
Thank you, Richard, and good afternoon, everyone. It's a real honour to be here and addressing all of you. I'm going to try and do a bit of a whistle-stop tour through the cases we've been running, maybe not quite as quickly as Joshua's 2 minutes per case of yesterday, but I'll try to keep it quite tight and just to key issues. And I think that you'll probably see that, although, as Richard said, not quite totally on point with the topic of this colloquium, they do raise issues of inequality and dignity and justice on an international scale. And we're here, obviously, way of access to justice of the victims at particular times, so obviously the legal landscape continues to change. So just a run through some of the cases that we've been bringing. The first case concerns a mercury processing plant operated by a British company called Ford Chemicals, which used to operate in the UK, came under a lot of criticism in the 80s by the Health and Safety Executive, the regulatory health body there, criticisms that there were very high levels of mercury found in the blood and the urine of the workers. The director eventually got so sick of getting criticised and being forced to take action at his factory in the UK. He literally closed it down and shipped its plant, factory, everything over to South Africa, to Natal province in South Africa, where again used the same techniques that he'd been criticised for using in the UK. And practice a particularly callous process of recycling workers, that they would reach a particular level of mercury, would get into their blood. He didn't want them to die, so they would be sort of relieved for a bit and then brought back again. And eventually 3 workers did die, and criminal proceedings were brought in South Africa, where a fine equivalent to £3,000 was levelled against the company, which did not have a massive deterrent impact. And the company ran via the UK parent company as well as a subsidiary company in South Africa. And that's how we came to be instructed because of the UK connection. And we ended up commencing a claim on behalf of 20 men, families of those who died, as well as those who were very sick from mercury poisoning. And we argued, we didn't argue for a piercing of the corporate veil, but we argued that the parent company was so intrinsically involved in running the plant on the ground that it had direct liability. It was responsible for the negligent design and transfer and setup and the operation of the plant. Thor unsuccessfully tried to stay the action on the grounds of foreign non-convenience. It was accepted that because the allegations centred a lot around the torts that took place and the breaches that took place in the UK, at the boardroom level in the UK, that was sufficiently connected to the English jurisdiction. And after a few years, the claim was settled for £1.3 million, so significantly more than the fine and costs as well. The company was ordered to pay costs. It's worth noting that that case was also funded with legal aid, with British legal aid. That the Legal Services Commission in the UK recognised that there was a public interest in providing public funding to citizens of another country who had allegedly been wronged by a British company and where proceedings were being brought in a British court. A second wave of claims was then brought, and shortly before trial, that one got a lot closer to trial, as is often the case with second waves of claim, that the defendant fights a lot harder. Very shortly before court, a month or so before court, we became aware that the company was restructuring and seeking to divest itself of millions of pounds, and the court accepted that there was an inference that this was in some way related to the litigation and trying to avoid having to pay damages, so ordered the company to pay money into court, which eventually did go to the claimants. The second case, again in South Africa, concerns Cape PLC, which, and some of you may have heard of this, the case Lugger versus Africa versus Cape PLC. Cape, again, an English company, first formed in the late 1900s, essentially an asbestos milling, mining, processing company with a global operation. It first established an asbestos mine in South Africa in 1913, mining blue asbestos, really the most deadly type of asbestos. And shortly afterwards it opened a factory in London, just on the outskirts of London, where it was processing some of this asbestos. It had opened various mines and mills in South Africa. And again, the English company was directly operating these mines until 1948. Thereafter, it did set up some companies which were wholly owned, and which again we said it was controlling it. It had control over all financial decisions of any value, which in turn impacted on their health and safety. And it's fair to say that it completely exploited the apartheid regime in South Africa. Predominantly, its workers were black, coloured, and had really abysmal health and safety of the mine. Many children were employed. I've met many of those who survived into adulthood, that were involved in actually picking out asbestos fibre with their bare hands from rocks, on trampling it down in sacks. And some of the disclosures that we got was it sort of meant a skin crawl. There were comments that the masks, they couldn't find masks that would fit sort of the African face, so they didn't